Namaste and welcome to the next session, the very first session of a new topic wherein from today onwards we are going to discuss on the things that are there on the screen for all of you. Yes, dear students, from now onwards, from this session onwards, we are going to talk on yet another important topic of our syllabus, and that is about the SEBI's Issue of Capital and Disclosure Requirements Regulations of 2018. As you can see, the heading is there for you on the screen. Now, before we can move into the technical part of this particular topic, before we can move on into the details of this regulation, as a routinal culture of our classes, let us first try to unfold how did this particular topic became a part of your syllabus and how did these regulations became a part of your course content, why you are required to study them, and how will you be benefited after studying this regulation in your syllabus. Well, by now, all of you must be acquainted with the fact that Securities and Exchange Board of India happens to be the chief regulator of the Indian securities market. On to whatever stage you are hearing this particular session, you know that SEBI is the chief regulator of the Indian securities market, and it has been so designated since 1992 after the Securities and Exchange Board of India Act of 92 came into existence. Since then till today, in order to promote its twin objectives of protection of the interest of investors and also to promote and regulate the Indian securities market, SEBI has made multiple regulations to regulate each and every category of the participant of the Indian securities market, be it the investors or the borrowers, or even those multiple intermediaries who are operating in the Indian securities market. SEBI exercises a control and a watch on each of these participants. As a result of this, there are so many regulations that have been issued by the Securities and Exchange Board of our country that not just only provide conditions in relation to the eligibility criteria for various intermediaries or for the corporate borrowers to enter into the market, but then at the same time, these regulations also provide for the provisions in terms of penalties that shall be imposed in case you do not comply with them. At multiple points of time, SEBI issues so many guidelines and circulars to cater to the need of securities market stakeholders. And one amongst that is the Securities and Exchange Board of India's Issue of Capital and Disclosure Requirement Regulations of 2018. All put together, if I can tell you the importance of this particular topic that will talk to you about the issue of capital by the borrowers, the corporate borrowers in the market, and the disclosure requirements pertaining to the same, then it would be a full justice if we can say that public issue happens to be one of the most important way through which a borrower can raise funds from the public. All of you are aware of that private companies are not the ones that can resort to this means of raising the finance owing to the restrictions that are imposed upon them under Section 2, Clause 68 of the Companies Act, and that are also enshrined in the articles of every private company. So it is the public companies, the corporate public borrowers who look out to the stock exchanges as a means of raising funds to finance their requirements. Traditional instruments of equity shares and debentures have been always the most common source of raising funds for the requirements of the borrowers. But with the passage of time, with the growth and development of the securities market in India and across the globe, there were multiple options that came in front of us as an investors to subscribe to and to provide that money, that much needed funds to the corporate borrowers. There were multiple types of instruments that can be issued. There are multiple types of instruments that can be issued through which the funds are mobilized from those who are having it in excess to those who are in need of the same. And that's how this market, as a part of the financial markets, plays a very important role in the rotation of money. Now, as far as raising of funds from the public is concerned, this public issue or this way of raising the money from the public with a public issue happens to be one of the most important steps that any corporate borrower can take in its entire lifetime. And owing to this very reason, this public issue of securities is something that's going to involve coordinated efforts and demands the cooperation of all those agencies who are associated with that particular issue of the borrower. Because it is not just a kid's game wherein 2 or 3 or 4 people or agencies can plan the entire issue and you can come up and raise the funds and fulfill the requirements. There are a lot of formalities in terms of eligibility criteria and ranging up to various types of permissions and approvals that you need to procure from the regulator of the securities market, who is SEBI. As a result of this, and just so as to ensure that the corporate action of public issue does not cheat the investor's confidence, does not harness the investor's confidence, it was needed that we should have some set of regulations that can provide the entire guideline as to how can you raise the funds from the public. We know public issue is an important way through which an unlisted borrower can enter the market, but then it is just not like you see, you plan, you think and you just enter. Like casually, no, it isn't. It has to be a planned, coordinated effort. Not just of the borrower, but those handful of intermediaries who are also associated with the borrower to ensure the success of these kinds of issues. And that's why there was a need that we should have one such regulation that can regulate each and every single step and the formality that is involved in these kinds of issues. Right from the day the board of directors of a company takes up the decision that they need to come up with a public issue, up till the date of the board meeting wherein an allotment has to be made based on the level of public subscriptions and allotting those shares of securities to the investors. In the midst of this, there are a lot of formalities and each and everything needs to be regulated properly and effectively. As you can see on the screen, there are multiple intermediaries that I have named for you who are associated with a corporate borrower at the time of issue, whether it is the merchant banker or the brokers, whether it is the underwriters or the registrars, legal advisors, solicitors and other government and statutory agencies. That of course includes our very own registrar of companies, Reserve Bank and SEBI of course. So with this intent of coming up with a public issue wherein we want to sell and market our shares or other securities, we need to comply with certain regulations, and that's how and that's when the regulations of SEBI comes into existence. Way back in the year 2000, SEBI formulated the disclosure and investor protection guidelines. As you can see, I have mentioned it over here, but not that much of details because these guidelines have now been rescinded and it's been almost more than a decade. But keeping in mind the situations of India and the Indian securities market in the year 2009, SEBI formulated the disclosure and investor protection guidelines. That's what we call in short as DIP guidelines. That not just only pertains to those multiple disclosures that were required to be made by the corporate borrowers when they were coming up with public issues, but also provided for those numerous steps that were being taken to ensure investor protection. Henceforth, the name was justified, Disclosure and Investor Protection Guidelines. But with the passage of time and the growth of the Indian securities market and of course the international markets, these guidelines started becoming obsolete. And then there was the time of 26th of August 2009, wherein these guidelines were completely rescinded by SEBI. And what came in front of us was the issue of capital and disclosure requirement regulations of 2009. At that point of time, these regulations were totally in tune to the growth index of the Indian securities market, and also provided for all those multiple measures that can ensure that the Indian securities market could compete at the international levels. But all of us are aware of the fact that laws are always made in order to regulate the human activity. Since the days of your foundation examinations or since the days of your entrance test, you have always been studying. You had always studied at even the stages of executive and in the other examinations that laws are made in order to regulate the human activities. Because that's what we need to regulate. Come on, we do not need to regulate the activities of the nature. We do not need to regulate the activities of any other element of the nature, because they are in any case more disciplined than the human beings. More disciplined. Much more disciplined, rather, if we could say, than the human beings. We Homo sapiens are the ones who need to be regulated, who needs to be properly regulated, because this is our very own nature, that if we have been stopped on the way, on the route 1, we'll find out the route B. If we've been stopped on the route B, we'll find out the route C. And if a barricade is being put up on the route C, we'll find out the route D. That's how we do for most of the times during the peak traffic hours on the city streets. When what we do is to find out the ways from those internal streets in the city wherein we do not face that high traffic or those traffic signals. But for most of the times, the situation is totally opposite. The traffic on the signals happens to be very smooth, whereas those alternative ways that we usually find out in the internal city streets and through the various colonies, they get trafficated, and we end up pressing and bumping onto our vehicle horns because we could not find out that way and that smooth traffic. That's a human tendency. If you stopped for one thing, you immediately find out the second thing. Well, if we can take that exact Hindi word that has often been used in English even with human beings, the word is jugaad. And we human beings are experts in this jugaad. Whatever it is, we know how to get the jugaad, right? Whatever the situation be, we know how to get the jugaad. And that's why our activities happens to be so inconsistent, so dynamic. If you can see an animal, if you have a pet in your house, if you have a pet, you would have definitely noticed that there are some specific places wherein you will see that pet lying down casually and calmly for most of the times. Until unless they're roaming in the entire house and they're playing and doing all sort of things with you, when they are relaxing or when they are in that state of being calm, there are one or two specific places that they will select, and they're going to rest on those places only. Those places only. But if you talk about human beings, our activities never are that consistent. And that's why we have laws. And that's why laws are always subjected to amendments, changes, because human nature changes. Law isn't like those scientific principles that are universally applicable and stands good at all the points of time. All the points of time, and when I say all the points of time, had it been that century, that time, that era wherein an apple was being dropped from a tree on the head of the Isaac Newton, or it is current times, even if I am sitting underneath a tree and a fruit drops down, definitely it will drop down on my head, on me, and it is not going to flow above in the sky. Because the law of gravitational force keeps attracted everything to this planet. And this gravitational force is universally present on the entire planet. So if I sit underneath a tree, even in India or in United States or in Australia or even in China or Japan or Malaysia or Africa, anywhere across the globe, that fruit, that apple is going to fall down on my head only. Right? That's what the universality of the scientific principles is about. E is equals to mc square happens to stand good at all the points of time. But the way that apple or a fruit is being marketed or sold in the markets and the way the profit is derived therefrom, the laws that regulate the derivation of profit from that sale happens to be different from place to place, from country to country, from region to region, because people are different. The living standards, the purchasing power happens to be different in India and definitely different in United States. There's a lot of difference in the likings and desires of the people who are living in India, and there's a lot of difference in the preferences and the dislikes of the people who are living in China. This is human inconsistency. This is human nature, because it is never consistent, because it is ever changing and dynamic. The laws that regulates it needs to be dynamic enough. The laws that regulate the human behavior and the human activities needs to be dynamic enough to permit all sort of these changes. Okay, if I can give you a very interesting example as to why are these amendments are a part of the laws and how do these amendments at some point of time cannot be entertained and we need to come up and review with an altogether new law. Let's take that simple and an interesting example. You know, all of you, when we were like 9 or 10 years of our age, and most of the times when we are in that particular age span, we do not go out for shopping and for buying clothes and other accessories for us every now and then, just like we do when we are sitting in this age today, right? Now we are more shopaholics and now we prefer more of shopping for all of us. But when we were into that age of 9 and 10 and 11 and 12 years, mostly like once or twice or thrice or even 4 times in a year, we used to go out with our parents and used to buy new pair of clothes for us. And for most of the times in the Indian rational and conservative families, because that's how we Indians are, conservative and rational, when the kids belong to this particular age, the parents, when they go out to buy some clothes or some similar accessories like a pair of shoes or similar other thing, they always prefer a size bigger than what actually fits their child. A size bigger what actually fits their child. Like if I fit into size 25, mostly the parents will ask for give us size 26 or 27 so that it is useful for at least some year or two, because the child is in the growing stage. And when the child is in the growing stage, if I take the cloth, the apparel that exactly fits the child, very soon it will be out of use, because the child won't be able to use it as the child is in the growing stage. And so the parents ask for a size or two bigger than what actually fits their kid. And very happily, we get that cloth with our parents, we buy that, we wear it on our birthdays or on some occasions, some festivals. And we continue to wear it for like 6 months, 8 months, even an year. And then after some point of time, when we outgrow that apparel, outgrow in the sense, in the height or in our body physique or our body structures, we try to find an alternate use to that piece of cloth. There are so many alternative uses to that piece of cloth in our Indian families. Again, I'm marking because we are very conservative and rational people. So what we do is that we try and find out for the alternative courses to wear that particular piece of cloth. Either it happens to be like that piece of cloth that we are going to wear when we are at home only, because now we have outgrown that cloth and we cannot wear it when we go outside with our parents, so we are going to wear it when we are at home. At times we are going to give it or lend it to our younger brothers and sisters if they are in the family. Why? Because now it is going to help out them. It would be an additional cloth for them and they are going to happily wear that I am wearing my elder brother's or my elder sister's clothes. Even when that festival of Holi drops down in the calendar, we'll wear that cloth once again, because we do not want to take out those fresh new clothes from our wardrobe, right? And then after some point of time, the same cloth would be used as a dusting cloth in a house by our moms. So see how in the multiple forms we used that particular cloth. But after all these uses, there'll be some point of time and the cloth will be of actually no use. And after all that dusting and everything, it would be now time to throw that cloth into the dustbins. Laws work in an exactly same manner. When they are formed, we always keep in mind the past and we do some future predictions and prepare the laws. But as and when the time grows, as and when the development takes place, as and when the society moves ahead, the laws slowly and gradually start losing their importance. We try to make amendments in them, and the same very thing happened to your ICDR regulations of 2009. Since 2009 till date, there have been multiple amendments and changes that we made in the regulations so that we can raise up the level of the Indian securities market to fit it at the international levels. So that the Indian markets can compete at the international levels, we ended up making multiple amendments in these regulations. But then, the fact was that there had been a time wherein a need was being felt that now we need to review and realign these ICDR regulations so as to make them helpful and cater to the development needs at the national and international fronts. Because now the markets have been growing in every inch and bit. And therefore, we need to review these regulations. 2009 was again a decade before. And now the markets have outgrown. And now the international standards have grown. And so as to raise our levels to the said increased levels, we needed review and realignments. Now, there are no chances that we can make further amendments. Now, there are no chances that we should go for those amendments few more times. Now, we need to realign our existing regulations so that we can fulfill the needs of the national and international aspects. We needed to realign them in a manner so that we could compete, so that the Indian corporate borrowers could compete at the international fronts. And that was when, under the chairmanship of Sri Prithvi Helidia in the year 2017, in the month of June, we established an ICDR, constituted an ICDR committee that was being given the task to review and realign these ICDR regulations so that they can ensure adoption of best international corporate practices and securities regulations. The committee worked on this task rigorously And based on the recommendations of this committee and of course the various stakeholders, because that is again very important, the views and the opinions of the stakeholders, because ultimately at the end of the day these are those set of people who are going to be most affected by these regulations. So whether it's the corporate borrowers or the investors or those multiple intermediaries who are operating in the Indian stock market, after taking into views and after consultations with all these stakeholders, finally on 11th of September 2018, SEBI announced for the ICDR regulations 2018 to be effective from the 60th day of its publication in Official Gazette. It was being announced on 11th of September 2018 that these set of regulations shall be effective once they are being published in the Official Gazette. The day they get published into the Official Gazette, 60th day therefrom. Effective from the 60th day of its publication. As on date, when you are listening to this lecture, as on date when you're hearing to this lecture, these regulations are very well into effect. And that's how we are going to study our ICDR regulations 2018. That's how these regulations came into existence. So dear students, I believe by now you're very clear as to what we are going to study in our upcoming sessions, what the topic is all about and why you are studying it. How did it go into existence is something that you are very clear by now. Some more things that we need to proceed ahead with in today's session. As far as the applicability of this regulation is concerned, in the sense, what are those various kinds of issues on which these regulations are applicable? Now, a question may pop up in your mind, are there multiple types of issues? I mean, it's just like public issue. We have heard for most of the time public issue wherein a company, a corporate borrower moves to the stock market, raises the funds, fulfill the requirements, returns the money, generates the return, and just so simple things. But now, the market isn't that very simple. The way we think it to be. There are multiple kinds of issues and there are various ways through which a company can raise funds in the securities market. The diagram that's there on the screen for you tells you the names of all those various types of issues through which the funds can be raised by an Indian borrower in the Indian market. And also, we are going to understand about some of those sources through which international markets can be targeted as a part of this subject, as a part of our syllabus. But as if for now, since we have started off with the very basic things, so what we have to study is only these various kinds of issues that can be bought in the Indian securities market. And if you can list them out, if you can study each one of them individually, then see what the things are there for you on the screen. The first and the most prominent one is actually a public issue. These regulations are applicable on the public issues, on all the kinds of public issues. Now, madam, what do we mean by a public issue? So here comes the explanation for you on the screen as to what do you mean by a public issue. Of course, it is the issue of shares or securities to the public by a corporate borrower for the purpose of raising funds. That's what we call public issue as. And that's what it is being written over here. See, an issue or an offer of securities that is made to the public by the issue of a prospectus and which is then being further classified into following parts. So it's a corporate borrower. That has to be definitely a public company. It is wanting to issue certain securities to the public in the market. And when it comes up with this kind of an issue wherein it is going to offer the securities with the help of a prospectus, that means a document in which entire details as to what the issue is about, what the instruments are to be issued, whether shares or debentures or bonds or warrants or other securities. What are the terms and conditions? What is the tenure? What is the rate of interest that is offered? Each and everything, plus where the company is going to invest the money that is procured through this public issue, that is collected through this public issue. Each and every such detail is mentioned in this document, what we call as a prospectus. For public issues, prospectus is must. Without a prospectus, you cannot come up with a public issue. There are few aspects as to what is a prospectus and how do we make up a prospectus that will fall in the later parts of your syllabus in the same chapter. But as if for now, the definition for the public issue is quite clear to each one of us, and that is an offer of shares or securities, an issue of shares or securities to the public by a corporate borrower through issuing a prospectus. But then it is generally classified into two parts, and these two parts happens to be number one, an initial public offer, and number two, a further public offer. Now, what's an initial public offer and what's a further public offer is something that needs a bit more explanation. When a corporate borrower approaches the platform of securities market to raise the funds for the very first time, we call it as an initial public offer. It's just that the first time. The first time. Everything has a first time, whether it's the first day to the school, or it is the first day to the university, or it is the first day on the job. But the first day is only once. And only one day is called as the first day, rest all the days are the subsequent days. Just in the same manner, when a borrower resorts to the platform of securities market and raises the funds from the public by issuing a prospectus for the very first time, this kind of an issue is called as an initial public offer. When the securities are offered by the borrower for the purpose of subscription to the investors, and this is the very first time when it is offering the securities through the stock markets, through the securities market. This obviously means the borrower has to be an unlisted one. Because unlisted means the one that is not present on the platform of the stock exchange. The one that is already present on the stock exchange, the corporate, the company that's already present on the stock exchange is called as listed. But come on, few seconds before we said you are resorting to this platform, you are moving to this platform for the very first time to raise the funds. Definitely you ought to be an unlisted borrower. See, the definition states the same. It is an offer by an unlisted issuer. Unlisted issuer. Now the offer pertains to what, ma'am? The offer pertains to specified securities, and this is the term that you need to understand right now. ICDR regulations are applicable only on the issues of specified securities, and specified securities includes equity shares, plus all those securities that are convertible into equity. Equity shares and all those securities that are convertible into equity are jointly called as specified securities. And when these specified securities are being issued by an unlisted issuer to the public for subscription for the very first time in the form of an offer for sale, it is called as IPO, that is initial public offer. Offer for sale wherein the existing holders of the securities offers their shares, and these are then offered to the public to subscribe, not the existing shareholders. We take from existing and offer to the public. If you offer to the existing, it is going to be a rights issue. It is that we are taking from the existing and we are offering for sale to the public and moving into the stock market for the very first time. And when you move into the stock market for the very first time, this is where your public issue is called as an IPO. An IPO shall always be bought by an unlisted issuer. Remember this and fit this into your top stories. Yeah, here, the top story. IPO shall always be bought by an unlisted issuer. Once your IPO is out and once you are present on the platform of the stock exchange, it's where your status shall change to listed. Now you know that better than me, the change of status, right? So this is how the status changes. IPO is always of an unlisted borrower or issuer, that's what you call it. And once you come up with this issue and this issue is floated in the market, subscribed by the investors, you become a listed borrower. And after that, whatever issues you come up with, however issues you come up with, it shall always be termed as a further public offer. Always a further public offer. Because a further public offer means an offer of specified securities by the listed issuer to the public for subscription. So if it's the first time issue of the securities to the public for subscription, in the form of offer for sale from the existing shareholders of the company, it's called as an IPO. And if it's the further or the subsequent issue of securities to the public for subscription by a company, an existing listed issue or company, it is called as FPO. To be an IPO, two major conditions should be fulfilled. That's here where I am mentioning. In order to qualify for an IPO, the offer has to be by an unlisted issuer, point number 1. It has to be by an unlisted issuer, point number 1. And point number 2, the issue shall be made to the public and not to the existing shareholders. It shall be made to the overall public. Then only it will be an IPO. But to be an FPO, it has to be an offer of securities to the public other than the existing shareholders. Because if it's existing shareholders or selected group of persons, it is named as rights issue or private placement respectively. So remember that difference. The offer is to the public, it is public issue. It's very simple. If I can write that down and explain you, if we say public issue, then it has to be specifically for the public only. It has to be specifically for the public only. Your subscribers to this issue, dear students, will be only public and no one else. Only public and no one else. Now, if it is for the very first time, it would be an IPO. And if it would be subsequently, it would be an FPO. When you come up with an IPO, you will be always an unlisted borrower. But once you come up with an IPO, you become a listed borrower and all your FPOs would be termed as the FPOs of a listed borrower. When you go to public, it's a public issue. When you do not go to public, it's not a public issue. Okay? And this means that if you go to your existing shareholders, in that case, the subscribers is not going to be the public. And the subscribers shall be your existing shareholders only. And when your existing shareholders are your subscribers, we call it as a rights issue. It can be even a bonus issue. If it's FOC, that's free of cost. And if it is certain selected persons or people, it will be a private placement. I suppose the point is clear to each one of you and you're trying to understand at least that what are we studying. Okay? And so moving ahead in our discussion, after understanding the IPO and the FPO, that is the public issues on which these regulations are applicable, you can see we have something else called as a rights and a bonus issue. Now, just now I explained you what a rights or a bonus issue is. You also have the explanation to the same here right in front of you on the screen, the rights and the bonus issue. What is the rights issue, madam? The rights issue is this. The shares offered by an issuer to the existing shareholders based on their shareholdings in the company on a specified date that is called as a record date. It's called as rights issue. Whereas in a similar manner, when the shares are being offered to the existing shareholders of the company on the basis of their existing shareholdings in the company as on a specified date, but something which is offered them for without any consideration, we call it as a bonus issue. Many a times, bonus issue is also called as capitalization of profits or reserves, because the company does not ask for a single penny from its shareholders. It's just that the company adjusts the excess balance of reserves that is available or profits that is available to it, and the shares are being issued to the existing shareholders. That's why we call it as a bonus issue. For this, then we also have some more kinds of issues. You have the third kind of the issue, and that is private placement, and also QIP, that's qualified institutional placement, and preferential allotment. Now, what is this, madam? So you have the explanation right here in front of you to explain what is a private placement, what is a preferential allotment, and what is a qualified institutional placement. As far as private placement is concerned, it's just that the issue of shares or securities is intended only to or for a selected group of persons. See, I have highlighted the concept that I'm talking about, and these selected persons or group of persons are not going to exceed 200. Also remember that there are certain provisions in the Companies Act that are provided in section 62 and 42 that needs to be complied when a company is coming up with a private placement or a preferential allotment. So now this time we are not going to existing shareholders. We are not going to existing shareholders. We are not going to general public. We are going to a selected group of persons. Selected group of persons. That too, the number of allottees shall not exceed 200. And such a kind of an issue with some additional conditions that needs to be complied with shall be called as private placement. Private placement. It's not a public placement. I'm not going to the general public. I'm not targeting the general public. I'm just targeting selected people. And that's why it's private placement. Right? When in the same manner, I target selected people only for the purpose of issuing of shares or convertible securities, I do target the selected people only, selected group of people only, but then when I need to comply with certain additional guidelines that are given in the chapter 5 of ICDR regulations, my issue is termed as a preferential allotment. Some additional conditions that are provided under chapter 5 of the ICDR regulations, when they are being complied with, and the issue is not meant for the general public, neither to the existing shareholders, but only to a selected group of persons, I call it as a preferential allotment. So there's a difference, a minute difference in private placement and preferential allotment, but the difference is a difference. Private placement has general conditions that are prescribed under ICDR. Preferential allotment needs to comply with additional conditions prescribed under chapter 5 of the ICDR. And then last but not the least, when your issue of shares or convertible securities is meant again for a selected group of persons and not the general public or your existing shareholders, but these selected persons or group of persons shall only be the qualified institutional buyers, that is QIBs, and you need to comply with chapter 6 of the ICDR regulations. You call this kind of an issue as a qualified institutional placement. So its base happens to be the same, selected persons, whether it is private placement, preferential allotment or QIP, selected persons. But selected persons not exceeding 200, private placement. Selected persons alongside conditions of chapter 5 of ICDR, preferential allotment. Selected person shall include only qualified institutional buyer or investor, alongside chapter 6 has to be complied, qualified institutional placement. Now, what are QIBs or qualified institutional buyers? Then let me tell you, the market has three categories of investors, and these three categories of investors are the retail individual investors, just like you and me, who when trade in the stock markets and get their demat accounts, we are termed as retail individual investors. Then we have certain types of institutions like the asset management companies, example mutual fund company and the collective investment scheme companies, that are designated by SEBI as specially qualified institutional buyers or investors. Alongside, we also have non-institutional investors. So all put together, we have three categories or kinds of investors in the market. But when your issue is specifically targeted only to the QIBs, you comply with Chapter 6 of the ICDR regulations, your issue is termed as qualified institutional placement. And my dear student, onto all these kinds of issues, ICDR is applicable. Onto all these kinds of issues. So by now you can guess and you can at least make out that ICDR happens to be one of the most detailed regulation that is framed by SEBI. In addition to others, like we even have that takeover code, the substantial acquisition of shares and takeover regulations that are quite detailed enough, but ICDR happens to be equally detailed because this isn't the only things on which the regulation is applicable, but apart from rights issue, preferential issue or your bonus issue, there are so many other things also on which ICDR is applicable. The list is there in front of you. The last 3 points, FGH. It is applicable even on the IPO of IDRs, Indian Depository Receipts. Indian Depository Receipts are those depository receipts through which the funds are being mobilized from the Indian investors by the foreign borrowers. So if a foreign borrower is coming up with an IPO in the Indian securities market, that's what we call Indian Depository Receipts, ICDR shall be equally applicable. Even on the IPOs of small and medium enterprises, that is SMEs, and then we also have an innovators growth platform that provides for the listings and other requirements for SMEs. So all put together, on all these kinds of issues, ICDR is applicable. And so now I believe that the things and this session makes you very, very clear and acquainted with the fact as to how did ICDR came into existence, how it was being amended, and what we are studying today are the updated ICDR regulations of 2018 that will include a lot of conditions ranging from eligibility criteria to the post-issue formalities. But as far as this session is concerned, these are the only things that I wanted to be aware of. These are the only things that I wanted to teach you as a part of this session. For the remaining conditions, for the remaining things, we are going to meet in the next lecture. Till then, kindly revise these concepts and I'll see you in the next lecture. Bye-bye and take care.